The conflict began with a notice that sounded routine but carried a threat that felt final. The HOA claimed I was violating community rules by parking on the street overnight. The notice demanded immediate compliance and warned that fines and towing would follow if the issue was not corrected. The language was confident, absolute, and presented as non-negotiable. There was only one problem. The street in question was not owned by the HOA. It was a public city street. At first, I assumed this was another case of overreach that would quietly resolve itself. Many HOA notices rely on broad language and vague authority, and often disappear when questioned. But this one did not. A second notice arrived days later, reiterating the violation and escalating the consequences. The HOA made it clear that it believed it had full authority to regulate parking, regardless of ownership. That was the moment the question became unavoidable. Who actually had authority here, the HOA or the city? Most homeowners assume HOAs outrank municipal rules inside a community. That assumption is deeply ingrained. HOAs feel official. They send formal letters. They reference governing documents. They impose fines. Cities feel distant by comparison, abstract and slow. In practice, that perception is often wrong. Authority does not come from confidence. It comes from jurisdiction. I started by reviewing the HOA's governing documents. The CC and RS referenced parking rules, but the language was carefully limited. Restrictions applied to common areas and HOA-owned property. There was no explicit grant of authority over public streets. That absence mattered. Authority must be stated, not implied. Next, I checked city records. The street was clearly designated as municipal property. Maintenance, signage, and enforcement were all handled by the city. There were posted city parking regulations, and none of them matched the HOA's claims. Overnight parking was permitted under city law. That created a direct conflict. The HOA was enforcing a rule that contradicted city code on property it did not own. When I raised this in writing, the response was immediate and dismissive. The HOA claimed that community rules supplemented city law and that homeowners agreed to comply by purchasing property in the association. That explanation sounded convincing, but it collapsed under scrutiny. HOAs cannot override city law. They cannot create parallel enforcement systems on public property. And they cannot punish homeowners for conduct that is expressly permitted by municipal code. Contractual agreements do not grant jurisdiction where none exists. The HOA continued enforcement anyway. Warnings turned into fines. Notices referenced escalating penalties. Towing was mentioned explicitly. The confidence of the letters suggested certainty, but certainty is not proof. I contacted the city directly and requested clarification. The response was clear and unambiguous. The city alone regulated parking on that street. The HOA had no authority to issue citations or request towing there. That confirmation changed everything. I forwarded the city's written response to the HOA and asked a simple question. On what legal basis are you enforcing this rule? I requested statutory authority, not internal policy. I asked how the HOA believed it could supersede municipal jurisdiction. The reply took longer this time. When it arrived, the tone had changed. The HOA no longer cited authority directly. Instead, it referenced community expectations and long-standing practices. There was no mention of law, no mention of jurisdiction, just tradition. Tradition does not confer authority. What became clear was that the HOA had been enforcing this rule for years without challenge. Homeowners complied because resistance felt risky. No one had forced the issue into a legal comparison. Once that comparison existed, the enforcement could not survive it. The HOA attempted to de-escalate quietly. Fines were suspended. Notices stopped arriving. The issue was never formally resolved or acknowledged. It simply disappeared.
No apology, no admission.
Just silence. This outcome revealed something important about HOA power. Much of it exists in the space between ignorance and assumption. When homeowners assume HOAs outrank city law, enforcement becomes easy. When that assumption is tested, the limits appear quickly. HOAs often operate as if their rules are superior because most people never ask where the boundary lies. City law feels abstract. HOA enforcement feels personal. That imbalance favors the HOA until jurisdiction is clarified. The real conflict was never about parking. It was about control. The HOA acted as if authority flowed downward from its rules. In reality, authority flowed upward from municipal law. Once that hierarchy was exposed, the enforcement collapsed. This pattern repeats in many HOA disputes. Noise regulations, street use, signage,
fines.
If the property is public, the city controls it. HOAs cannot fill perceived gaps with private rules. They can only enforce what they legally own and what the law allows them to regulate. Most homeowners never discover this because challenging authority feels dangerous. But authority that cannot be defended legally is not authority at all. It is habit. And habit breaks the moment someone asks the wrong question. The aftermath did not arrive loudly. There was no formal announcement, no clarification sent to homeowners, and no correction issued by the HOA. What followed was quieter and far more telling. The rules simply stopped being enforced. No new notices were sent. No fines appeared. The threat of towing vanished as if it had never existed. The HOA did not concede the point publicly, but it did not test it again either. That silence was not accidental. It was risk management. Once the HOA understood that its enforcement conflicted directly with municipal law, continuing the practice would have exposed it to consequences far beyond an internal dispute. Enforcing rules without jurisdiction opens the door to liability. Wrongful fines can require refunds. Improper towing can trigger civil claims. Repeated enforcement after receiving notice of illegality can be framed as bad faith. The city, by contrast, had nothing to adjust. Its authority had never been in question. City law did not change. The only thing that changed was visibility. Once jurisdiction was clarified, the hierarchy of authority became impossible to ignore. This kind of quiet retreat is common in HOA conflicts involving public property.
Association rarely admis au vérité.
Admission creates precedent. Precedent invites further challenges. Silence allows enforcement to fade without empowering others to question it openly. But the impact does not end there. After this incident, other HOA rules were interpreted more cautiously. Language in notices became less absolute. References to city regulations appeared where they had not before. The board avoided areas where authority could be questioned. The shift was subtle, but it was real. This is what legal aftershock looks like inside an HOA. One boundary clarified forces others into view. The larger lesson is not about parking or a single street. It is about understanding where private authority ends. HOAs exist within layers of law. They operate beneath municipal codes, state statutes, and federal protections. Their rules are not supreme. They are conditional. Most conflicts escalate because homeowners never test that condition. They accept enforcement as final because it is delivered confidently. But confidence is not jurisdiction. And private contracts cannot override public law. When an HOA acts as if it can regulate public space, it reveals a deeper assumption that no one will force the comparison. The moment someone does, the illusion collapses. This is why the most effective HOA challenges are not emotional or confrontational. They are structural. They ask simple questions that demand legal answers. Who owns this property? Which law applies? Where is the authority written? Those questions are uncomfortable because they cannot be answered with tradition or policy. They must be answered with law. In this case, once the law was placed beside the rule disappeared. Not because it was rewritten, not because it was corrected, but because it could no longer survive scrutiny. That is how HOA authority usually ends, not with a fight, but with exposure. And once exposed, it rarely returns.